Welcome to another video entitled Harvesting Legal Knowledge. And this is a collaboration between NDFB and Ohnstad Twichell Law Firm. And with us, we have Tiffany Findlay and Jenna McPherson with Ohnstad Twichell. Thank you for being here, ladies. We're going to talk about, estate planning is the topic at hand. And so estate planning is important for everyone to avoid tax implications, avoid messy situations, and overall ensure the farm is passed down to the next generation of farmers or ranchers in our case. And so we've got a series of questions here. First off, to start off, I guess, who needs an estate plan?
I think it's important to know that everyone can use an estate plan. When you're thinking about young families, farmers who are just starting off in the industry in particular, and of course, when you're nearing retirement, there's so many situations that we can avoid that could potentially get messy, or situations that you may not want to happen that we can plan for in advance and can continue planning for as we go through life. So I think that everyone could use an estate plan in some form or another.
Let's see, what documents does a person really need?
I think for the foundational documents, certainly a will, power of attorney, and healthcare directive are the three main documents every person really needs for their estate plan. The will governing what happens to your assets when you're gone, power of attorney governing who can make business and financial decisions on your behalf when you can't make those decisions, and healthcare directive to make healthcare decisions for you when you can't make those for yourself.
Very good. What happens when there is no estate plan?
When there's no estate plan, what we see happen is that we have to rely on North Dakota statute to govern who is responsible for administering the estate, or who actually receives the distribution of your property, who's paying for your debts. Granted that North Dakota statutes do take into account what the average family may want, but that's now more than ever not necessarily what a typical person may want for where their estate plan or where their estate should go after they pass away.
Yep, and statute will also govern who gets priority to serve as personal representative. And again, that might be the case, that might work out for some families, but for others, that's not really necessarily would have been their intention had they documented it.
Let's see here, more of a statement than a question the way it looks here, but isn't a spouse already a person's agent for financial and medical powers under law? Oh, isn't a spouse already a person's agent for financial and medical powers under law?
So we find that more and more small town banks or entities may allow a spouse to go in and act on their other spouse's behalf. But underneath the law, you do need to actually appoint an agent in order for that power to be effectuated. So during your lifetime, it's important to make sure that you do have a power of attorney document to appoint an agent to manage all of those financial matters, who can take care of business when you're on vacation, much less alone when you may be incapacitated. Same thing for your healthcare decisions, having that healthcare directive and appointing an agent, and also letting them know about what your wishes are for medical care is pretty important.
Just a little more explanation, I guess, of explaining wills, power of attorneys. Is there any more that you want to contribute to that, I guess, Jenna, at all?
I don't think so. I think a will can be as simple or as complicated as you want it to be. There's not really a one size fits all. And so that's why it's important to visit with an attorney to go over your certain situation, your financial situation, and your familial situations are all really relevant to drafting a well thought out estate plan.
Switch things up a little bit here. Talk about some of the impacts of real estate ownership on estate planning. So how does real property ownership affect your estate plan?
Well, as we've talked about before in another webinar, there are multiple different ways that you can own real property, in particular with another person. We have the joint tenancy or tenants in common types of ownerships, where you either own an undivided one half interest with the other person, or you own an undivided interest where, as soon as you pass away, your interest automatically does go to the other joint owner's names. We also, of course, have the life estate deeds, where you can grant the remainder interest to a person after you pass away, or a transfer on death deed as well, where we have some of those same considerations at play. There's a lot of different ways that real estate ownership can affect how we go about with the rest of your estate plan, and also can play into what we see in the future of particularly the real property and how that's going to be transferred through the generations.
Does transferring property while retaining a life estate provide adequate asset protection when beginning to transfer real estate to the next generation?
Yeah, so what that's a term, the life estate deed is a term that Tiffany referred to earlier as
Okay.
an option for owning real estate. And so what that does is you're conveying real estate to a child typically during your lifetime, and then you would retain the rights to the income for your lifetime. And then at death, that property completely transfers to the life, or excuse me, to the remainder interest holder. Um, do we want to get into Medicaid? Talk about the 5-year look back?
Might as well.
Yeah. Okay. So, in North Dakota, a lot of folks are interested in doing medical assistance planning, and so they will utilize a life estate deed as a way to protect that asset, typically farmland, sometimes residential properties, um, and they try to do that at least 5 years before they think they're going to enter the nursing home to protect that asset. There's a 5-year look back period
Yeah.
um, for entering the, for 5-year look back period for qualifying for
When you
Medicaid.
apply for
For Medicaid.
when you apply for Medicaid.
Mhm.
Okay.
Yep.
Yes. And I think another important consideration with a life estate deed too is that there are considerations compared to, say, a transfer on death deed to take into account where as soon as you sign that life estate deed, your children or whoever you granted that remainder interest to, they have a present type of interest. If they have creditors or if they pass away, that remainder interest can be subject to those types of things.
Or if they get divorced, like they're co-owning with their kids during their lifetime, which is can be a huge negative for some of our clients. That's just not something they're interested in doing.
Yeah, there are a lot of pros and cons with
Sure.
using the life estate deed, which is why a lot of people are, if they're not sure, maybe will use the transfer on death deed so that they can still go on and name very easily and simply the person they want that property to pass down to without some of those consequences. But then we don't have any protections like the 5-year look back protection against Medicaid asset inclusion.
Right.
So is it fair to say, like, the earlier the better when you're doing some of this planning? That's kind of typical for a lot of the answers I think of these topics we're talking about, but um, better to plan ahead of time rather than try to be reactionary after the fact.
Certainly, yeah, certainly. Certainly on a case by case basis, some folks aren't in a position to make those decisions either, and we don't want you to make a decision you'll regret later either. But I certainly think being informed and um, discussing these earlier, the better.
Uh, Again, shifting things a little bit here, talking about gift tax annual exclusion. When is a gift tax an issue?
So, gift tax is an issue when you happen to gift property or assets or, say, monetary values to another person. It doesn't need to be in your family. Right now, each person has a $19,000 annual gift tax exclusion amount, where each person is able to gift $19,000 to another person without needing to worry about gift taxes. And we, of course, also do have in here the spousal deduction, where you can, of course, gift as much or as little to your spouse as you want without any considerations when it comes to gift tax.
Very good. When do you need to file a gift tax return?
Gift tax return gets filed when you go over your annual exclusion amount. So, like Tiffany said, right now we're at 19,000 per year per person. If you go beyond that, you'll file a gift tax return, and then that whatever amount over you are of the annual exclusion amount, that will just deduct from your lifetime exclusion amount, which right now is 13.99 million per person.
Okay.
So that'll deduct, but there's no taxes owed necessarily. It's just reduced from that amount.
Have they ratcheted that amount up also over the years? I feel like, yeah.
Yeah, they usually do account for inflation every year. So right now, that number is 19,000. But yes, there is a good possibility that next year and continuing on, those amounts will go up.
And the 19,000, that's an aggregate total, so you can't just gift 19, 19, 19.
opposite as she'll get. Yeah. So I could gift if I really wanted to 19,000 to you, 19,000 to you. I'm sure you would like that. It's not. It's per person to receivee is the $19,000 limitation. So it does not need to be $19,000 per year per giftor, which is also another reason why, especially when we're looking at more and more uses of life estate deeds or other types of transitions to reduce your net worth, the gift tax exemption is used more and more because that is a very easy and good way to start. Exactly. It's a freebie to lower your net worth without any type of consequence on either the front or the back end.
Awesome. Do you need to pay anything when filing a gift tax return? Is there a cost associated with
No, so the only cost you'll pay on that is when you actually pay the filing fee or the paying the accountant per se to actually file that gift tax return. There is actually no tax due to the IRS when you file that turn. But like what Jenna said and what we'll discuss a little bit later on down the road is it may have some consequences when you do pass away.
Okay. Estate tax exemptions. So what does it mean to have an estate tax exemption?
So right now, I'll give an example. Everyone has a federal estate tax exemption, a lifetime exemption amount, where whatever they own at death is exempt from tax up to a certain amount. And like I said earlier, that amount right now in 2025 is 13.99 million. And so anything over that gets taxed at the federal tax rate, um, or the federal estate tax rate, excuse me. And so that's the exemption amount for each person.
Yeah.
And I can point out too, so not only do we have to sometimes worry about a federal estate tax exemption, but the states do have the option to also have federal estate tax due on your death. In North Dakota, we do not have any estate tax. However, on the Minnesota side, each person does have a $3 million worth exemption. So if you own any real property over in Minnesota, that may be something that you want to take into account when you're planning.
Okay. Good to know when we operate on the border here. So,
Exactly. Yeah.
and then this question, I don't know, you maybe covered this, but when is your estate tax amount calculated?
Your estate tax, so your net worth essentially at your passing out of your due to death.
death.
Exactly.
Okay.
Yep.
And
Very
it
good.
may be good to note there that when we are calculating how much tax, we can count the fact that there is also a spousal deduction when we're considering estate tax as well. So when you are passing all of your property to your spouse on your death, we aren't looking at any federal estate taxes due.
Okay.
And I think maybe just to piggyback off of that, so if everything passes to the spouse, you can also pass over the exemption amount. That 13.99 that you hold could potentially all be passed over to your spouse, so that when they die, they get the 13.99 million. And of course, we wouldn't know exactly what their exemption amount would be, but when they pass, they get to couple those together. So that can offer a lot of safe harbor for a lot of folks
Nice.
to avoid estate tax, and that's kind of a really big service that our firm offers for clients.
Okay.
It's a really nice inclusion. So it's called portability. And particularly this year, when we were looking at the estate tax exemption sunsetting and almost being cut in half into the next year, a lot of the clients where we had, say, spouses pass away this year, we wanted to make sure that we did file and port over that estate exemption so that we preserved that higher dollar value just in case something were to happen down the road and they did have a lower exemption rate.
Do you think there's a threat to that? Obviously, who knows with politics, right? And given an administration change or people being elected, senators, congressmen, whatever. But do you feel like there's a real potential threat to that amount being lowered in coming years, or have they kind of continued to ratchet it up, like you said, based on inflation? And is that just kind of political talk that it's suddenly going to be cut in half or something?
Well, there was an actual law in effect where it was supposed to sunset January 1st, 2026. However, the legislature has actually now gone on to start to raise that exemption amount up again. So, like Jenna noted, next year it will be 15 million and it will supposedly go up from there. Of course, we never know what the legislature is going to do. So, but like I said, our crystal ball isn't really clear. So.
we sometimes we have the term, with our phrase rather of it's the political football. It's kind of the thing that
Yeah.
can be tossed around, and certainly a way to kind of for the government to tax folks is at death. So we'll see.
We have a lot of political footballs, I feel like, right now that are up in the air and things being used.
For sure.
Uh, Move on to trusts, I guess. And so who needs a trust, and is a trust always the answer?
I would say most often my clients who are utilizing a trust own property in more than one state. They're trying to avoid probate, sometimes in their residential state or their primary domicile, but they're also trying to avoid probate. A lot of times we're seeing Minnesota and Arizona. Folks have a lake place, they've got a winter place, and they don't want to probate just one piece of property down there, so they'll put it into a revocable living trust. Or I oftentimes see a trust being utilized when we have a child we're trying to provide for that maybe shouldn't inherit outright, and they want to set some terms up, provide some structure for how their inheritance will be distributed to them over time.
Yeah, I'll say trust planning maybe isn't for everyone because of how complex it can be. A lot of different aspects of estate planning can be done without the use of a trust. When we're thinking about just utilizing a will, or a life estate deed or a transfer on death deed, those documents can accomplish a lot. But if there are more complex situations, or you have that one family member that you just don't really know about yet, a trust can be something that we look at. So it is important to note, there are a couple of different types of trusts. So we have a revocable trust, which can be changed at any given point up until the trustor's death, typically. And then we have an irrevocable trust, which is really the other hand of the revocable trust, where the irrevocable trust cannot, or at least should never, be changed. The terms are set as soon as you sign that document. There are, of course, reasons for using both types of trusts. The most consistent one that my clients have had with irrevocable trust planning is when we're looking at the potential for long term medical care in the future. Again, going towards the planning earlier is absolutely better. If we know that there's going to be some sort of those types of situations, an irrevocable trust can become very handy for those future scenarios.
See, I think the answer to this is no, but we'll try it. Does a trust always avoid probate?
No.
Absolutely not, unfortunately.
Yeah.
We have a lot of clients who utilize a revocable living trust in hopes to avoid a probate, but time and time again we find assets aren't titled correctly. Real property is sometimes inadvertently left out, requiring a probate, and so oftentimes we're doing trust administration and a probate together.
Okay. And do probates get a bad name? I mean, is a probate a bad thing? And then a secondary question: how expensive does this get when you go to probate?
I wouldn't say that probates, particularly in North Dakota and Minnesota, are a bad thing. Compared to some of the other states, they are more on the inexpensive side, and they don't take as long as maybe one may think. The typical probate that I've had with my clients has typically lasted anywhere from, say about 5 months to a year.
Okay.
It depends on the circumstances, the assets that are in the estate, if there are any issues that need to be dealt with before
Mhm.
the property can actually be distributed out of the estate.
Certainly litigation puts a major pause on a lot of that too. So if we've got an estate where we've got fighting or different interpretations of things, that really slams the brakes on things. But it should be noted that that's not just exclusive to probates. It can happen in trusts in both cases, really.
Yeah, things take time, especially when you're trying to do them right. So, although there might be some people who would prefer to see a probate done in a couple days or a couple weeks, sometimes that's just not, the case. There are a lot of complications when you start having things like real estate go through a probate. There are items that you need to check off before that property can be handed down according to the will or the trust distribution terms, or however that person has prepared for that property to go down.
So, when does a person need a probate? I guess what triggers?
Yeah, a probate in North Dakota is needed when an individual dies owning any interest in real property in their name alone, or if they have assets in the aggregate of $100,000 or more.
And it should be noted too. So, your real property interest, as long as it's held in your individual name, that can be something that is actually held in joint ownership. So, like when we're talking about tenants in common types of ownership, if you and your brother own an undivided quarter as tenants in common, your one half interest will need to go through probate to transfer unless you plan for it otherwise. Just because you have someone else named on the title doesn't automatically transfer it to that person.
Okay.
Exactly. We get that all the time. They say, no, 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 I own this with my brother. It's like, well, yes, but your own interest separate from your brother's in together. So
And what is the difference between a person's estate versus a person's probate?
Those terms are very confusing sometimes. So, the easy way that I like to delineate them is that an estate is always around you. Even right now, each of us has an estate. It's what we own. It's what debts we have. It's the persons who are helping us manage our affairs. Whether you have a power of attorney or a healthcare directive, that is all a part of your estate, and that continues on, of course, after death. The probate only happens when you have to go through the court process, when you own real property or when you have that $100,000 in other assets, that you have to actually commence a probate. Do you want to explain sort of what a probate maybe means?
sure, probate is really just the formal proceeding to appoint a personal representative, someone to take charge of the estate. They go out and they gather asset information. We typically publish a notice to creditor, shortening the period by which a creditor could come forward. We value the property. We might liquidate the property, or we might just distribute it outright. Farmland being an example of something that gets distributed outright. We value everything, provide an inventory to all the heirs or beneficiaries, and then just do a final report and account of what came in and what went out of the estate.
Okay.
And I should note too, one thing we haven't discussed yet is say payable on death or transfer on death designations. Those are items that will not have to go through probate. So if you own an account, either with a person, like say a bank account or an investment, or you've named a beneficiary as a payable on death or transfer on death beneficiary, those types of assets will flow outside of probate and will automatically be distributed.
They trump a will, they trump a trust,
Exactly.
and so they'll go to those beneficiaries directly.
Okay. I see the phrase farm succession planning here next, and I think a lot of people confuse that with like an estate plan or something like that, or just they seem commingled a little bit. But what is farm succession?
Tiffany and I laughed about this when we were building our presentation. Farm succession is a term that gets used a lot. And farm succession, I think to us is just how do we move the farming operation to the next generation? How do we keep the farm farming? Which seems kind of funny, but with buyouts prices the way that they are right now, you really have to have a designated plan to keep that farming air farming.
Yeah, exactly.
Yeah, there are a lot of different considerations that come into play when you do have a farm as part of your estate. There's a lot of different specific planning techniques that we can use both while someone is alive and after death to make sure that the goal is that the farm does continue. So the more that we can make sure that happens, the better.
And I think there's two broad categories here. It's if we have a farm successor, someone who's going to continue farming, and when we don't. And how does that work? And how is the real estate going to be titled when they're gone? Are they going to co-own it? Are they going to split it up? Are they going to sell it? Do they need to offer it to someone else specifically? Are there terms by which that person gets to buy it? All those things are considerations we make.
I see the phrase here down below. Fair doesn't mean equal. Can somebody talk about that a little bit more?
Yeah, I mean, we talked a little bit about this with our partition talk earlier on. Really, what this means is that, especially when we do have a client who has a farm, a lot of the times, if they have more than one person they want to give their estate to, we have to come to terms with there's not a lot of liquidity when there are farming assets. When you have quarters of land and you have expensive and new combines and other, tractors, other equipment, there's not really a lot of wiggle room that we can keep the farm together while also giving an equal dollar value to those non-farming clients. So there are different ways that we can plan to make sure that both of them are being compensated and given value, but they may not be equal in type of asset or even dollar value at some points.
I see another statement down below here, know your fair market value net worth, or what it is. And that's a tough one. You have comparable sales, I guess, and you can use things like that. But with an economy that's, kind of doing a roller coaster ride at times, it's tough to know, where am I at? And even with equipment's a little bit easier. I feel like you can keep a handle on that. But land is always it's what somebody will pay for it, right?
Exactly.
And so it's really that's a tougher one to try to sort out.
We utilize appraisals for the estate tax returns and inventories oftentimes to establish basis when someone has died, when that gets passed out to the heirs. But when we're planning and meeting with someone, especially a farmer, we want to know what the fair market value is. And that's kind of a difficult term to know, but undervaluing your assets doesn't help us plan. It certainly doesn't help us do tax planning if we don't actually know what the IRS is going to say your value is.
Particularly when farmland is more and more expensive nowadays. I mean, if we have land that it would actually appraise for $10,000 an acre now, and you have on your balance sheet that it's only $1,000 an acre, there's a little bit of a difference there that, if we don't take the full value into account when we're on the planning side, we could end up having to do more work when that person passes away, which I don't think any of us really want.
Right.
I see co-ownership at the bottom here. Can be great, in certain situations, but you might want to look at whether it's necessary, I guess, and whether you even need to co-own, whether it be land or assets. And what are your thoughts on that, I guess?
My preference is, if it's possible, split it out.
Yeah.
Individual ownership to me almost always is better than co-ownership, but I also understand that just doesn't always work. Like Tiffany said, we have a lot of estates that there's not a lot of liquidity there, and so it's hard to kind of even those things out, and every quarter is valued differently. And so that's my thought on co-ownership.
And it's important to know, who are you putting up as co-owners? Will you, thinking in your mind, will they get along? Will they continue on the same path? Do they have the same goals? If they do now, will they in the future? That's always the question. So, if you know of struggles, but they're willing to work it out, if you are willing to put, plans in place, there are different types of things like more specific co-ownership planning, or even looking into entities, or partnerships, those types of structures that we can make it work. But again, it's coming in and talking about those things and planning for them.
Covered a lot of information here. What have we missed anything that you wanted to mention that we didn't get to, I guess? Or the whole title of estate planning? If not, Tiffany, Jenna, thank you so much for your time. Did a great job. And if folks, I can imagine our members wanting to reach out to you in regard to a lot of these topics are huge with our membership base. So how do they get in touch with you, I guess, if they want to connect with you?
So we have a website, ohnstadlaw.com. That's OHNSTADLAW.com. We have over 5 offices, 3 of which are fully staffed. So I'm located in the Hillsborough office. Our main phone number is 701-636-5700. And
I'm in Castleton. Our number is 701-347-4652.
we, of course, have our West Fargo office as well. We're both very reachable by email, or if you want to stop in to either our Page office or our Matic office as well.
Awesome. Thank you so much for your time, ladies. And thank you for joining us. And be sure to check out our next video on this within this series.